Good day, everyone. My name is Mihaela Apostol. I am a UK lawyer and a Romanian lawyer, and I appear today on behalf of ARPTech, which is a discussion forum formed of legal tech people who are interested in the future of justice. On ARPTech, we try to encourage a dialogue between tech people and legal people, because sometimes we feel like we speak different languages, unfortunately. And we try to enhance access to justice. And this is the purpose of the presentation that I'm going to have today. I'm going to have a short overview of the court decisions so far on crypto issues. And here's the overview of the point I'm going to cover. Firstly, I would need to mention that this does not represent legal advice by any far. It's just an informative presentation, so do not take everything for granted, because this is just something very, very general, and all the points that I'm going to discuss need to meet further conditions to be actually applicable in practice. So I'm going to try to make it as simple as possible and hopefully as accessible as possible. First, I'm going to touch upon what are the most common crypto disputes. Then, secondly, what can a court do? Then we're going to talk about how you can serve your claim. And after you serve your claim, whether the court has the power to do something about your claim. And eventually, once you serve your claim, you need to prove it. And I'm going to touch upon how you can prove it. And the last point will be a bit brief in terms of what are the legal issues. I need to underline here that the court decisions that I've cited there are very general court decisions. The court did not go into detail to see if the parties actually have a right. It was something done very, very general because these were emergency application. Okay. So most of common type of disputes are fraud disputes. And this you have the classical of someone sending you a link and you click on it and then you realize that your wallet is empty, or you're the victim of a fraud attack or a ransom attack and so on. And I'm going to give an example here, and this is actually taken from a court decision where an insurance company has been subject to a hacking attack. They received this message on their monitor saying, look, we have encrypted all your files. If you want to take it back, you need to pay us this amount of money. And the court actually granted the application for the insurance company, and they were able to recover the money. So this is just a classical example of fraud. The next example is a breach of contract, and I'm not referring here in general to a contract that is stamped, signed between the parties, but it can also involve a contract that has been formed via exchange of emails or even a Telegram conversation. And here you have an example from a court decision where the court decided that a simple exchange of messages via Telegram qualify as a contract, as long as it's very clear what are the parties and what they are supposed to do. And you have here the quotation of the case in case you're interested. And I'm going to move forward with what can a court do, right? We go there, and what do you ask the court? What are their powers? And I highlighted there mostly the most common applications made so far. And one of them is property injunction, meaning that you claim ownership, a property over your crypto against another person. And the court can give a order saying, it's your crypto, the other person cannot use it, cannot do anything about it. And a bit further, which is probably the most sought order in the UK courts, is the worldwide freezing order. And this means that you go to the court and you say, look, I had crypto on this wallet, I've been hacked, they took my crypto. I want you to seize the crypto on whosever hands they are anywhere in the world, not necessarily in the UK, anywhere in the world. And we're going to see further that this type of application can be made against a person unknown. So even if you don't know who's the person who took your assets, you can still ask the court to order the decision against an unknown person, as long as you have some definable criteria, like, oh, I have their wallet number. I want the court to give this decision against the owner of this wallet number. And the third one is in connection with the other two. It's a disclosure order against third parties. And this one is when you go to the court and ask the court to force the trading platform or the platform that hosts the crypto to give information upon the wallet that took your crypto, or the IP of the person, or any traceable link to the person who took over your assets. The other one is a summary judgment. It's basically you want the court to give a quick decision on your case, and you don't want to spend a lot of time going to witnesses and having a lot of hearings. You just want a quick solution. The next one is a strikeout application. It's sort of a reverse remedy in terms of if someone is claiming ownership over your crypto and you're just drawn into court, someone saying that they have property rights of your crypto, you can ask the court to strike out their application and dismiss it quickly without going into the details of the dispute. And the last two are basically for the purpose of keeping the anonymity of the proceedings. And this is to protect the crypto owners. For example, if you've been the victim of a ransom attack, as we've seen previously, and you don't want that exposure, if you're an insurance company and if you have been hacked, you don't want the people to know. So you can ask the court to remain anonymous, or ask the court to have all these hearings in private. I'm going to move a bit further. How do you serve your claim? So we all know all these American movies with someone handing you the documents, you've been served. And apart from the classical way of serving a claim, there are some new ways of serving a claim, and the courts became very receptive and becoming a bit more tech-orientated. And you have here a couple of examples of court cases where the court accepted the service of claim on less classical means. And we have a service of claim via email, we have a service of claim via WhatsApp. So the court decided that those two thick blue lines are enough for you to prove that the other person had knowledge of the claim. And the third one, which I think is the most innovative, and this is quite recent, the example there is from the New York court, but we also have an example from the UK courts I think last week, where a person has lost access to their wallet and could not identify who took the wallet. And what they do eventually, they went to the court and said, please serve this application via NFT to this wallet, even if they didn't know the name of the person or the address or anything. So the court served the application via an NFT. I'm having a bit of trouble. Okay. The next threshold that you need to prove when you are at the court, you need to establish if the court has the power to intervene. I mean, you cannot go to every court in the world and say, oh, I want you to enforce this decision or do that. You need to have a connection with that state. And this is called, in the legal world, does the court have jurisdiction? Well, simply put, does the court have the power to do anything about your claim? And firstly, as a claimant, you need to establish that you are either born in that country, you resided there for a couple of years. There's a sort of connection. And as I said, you can remain anonymous. It's not necessary. You're not anonymous to the court. You have to disclose your name to the court, but your name will not appear in the file. And the second one is you need to establish who's the other person. Who are you arguing with? You can't just argue in thin air. And here, as I said, the court can grant application against people unknown unless you have some definable criteria, how to identify it. You don't need necessarily a name and an address in a classical way. And of course, if also you need to prove they have any other sort of connection with the jurisdiction. For example, that you have a bank account there, or maybe the loss happened there, or the tokens were someone stored physically in a place in that country. And now the most fun part, you need to prove what you want to from the court. And the question that arises, is blockchain data of any relevance for a court? Does the court recognize it? Does it have any value? And here we have two examples. One is based on the EU regulation. So at least at European Union level, there's a regulation, and you have there the quotation, where it says that electronic data stamped in specific conditions can be recognized in court as admissible, and under certain circumstances, it can enjoy a presumption of authenticity, as in no one can contest it. It's taken as it is. And as you will see here, in this quotation, the European Union does not use the word blockchain at all. It's something more vague, but there's something that might be helpful. So I came across this paper from the European Blockchain Observatory, and I look it up, and the European Blockchain Observatory is actually an initiative of the European Commission. So they have a voice of the European Union, and I think you can make an argument based on this, and of course further interpretation, that data stored in blockchain is admissible in court and has value. You have here the citation and the link in case you're interested. Oops. Okay, now under which conditions? So previously we talked what's happening in the European Union, and that will cover only 20-something countries. But what happens in other countries? So we have here an example from the Chinese courts. And this is a bit older. I think it's from 2018. Things might change a bit after. But what the court basically says here, where you have the underline, the bolded text, is that data stored in blockchain should not be put to a higher standard of proof or a lower standard of proof, should be taken in a neutral manner. And as long as it complies with certain conditions, you have it here in terms of certainty, trustability, and so on, it is admissible in court. Okay. Here, it's a bit tricky because it's legally heavily, but I'll try just to pinpoint the basics. And whenever you have a claim in court, the court will ask, do you have any rights over that asset? You can't just go to court, I want that. Okay, but you need to, after you prove, you need to prove that that asset is yours, and it signifies something from a legal perspective. And the first question that a court had to answer, is this a property? Can a crypto be considered a property, as a house, as a share in a company? And so far, luckily, I will say, at least the UK courts have been very open to this idea. And I've quoted here a case that refers to Ethereum and Bitcoin, where the court said that it has enough evidence to conclude that a crypto can be a property from a legal point of view. And this was just at the beginning when the court started to give decisions on crypto. But afterwards, they started to develop a bit more on the topic, and the parallel they made between a crypto and other property, they draw a parallel between crypto and a share in a company, because they are both, they don't have a material way, you cannot touch a share, but you know it's valuable. So that was the parallel to arrive to the conclusion that a crypto can qualify as a property. And the other important issue that appears whenever there is a dispute between a crypto owner and the platform, sometimes the platforms take more rights than the crypto owner think. And they start to claim ownership of that crypto. They start to trade that in their behalf and make money. And the question is, how, from a legal point of view, can the relationship between a crypto platform and a crypto owner qualify? And most of the courts have decided that this is a trust relationship. I will not go into detail, but it's a legal concept. But the idea is that you do not transfer ownership to the platform. If you can prove it's a trust, you remain the proprietor of your crypto. And here is on the slides a criteria that the court had in mind when deciding whether or not the account holder lost property of their crypto when they hand it to the platform. And one of the reasons why the court decided it's your property, it's not transferred, is because the assets were held separately from all the other assets of the platform, and it could be easy to identify which one was the property of the claimant. Okay. I've reached the final of my presentation, and I want to highlight that what I presented was a very, very simplified manner. And even if you have a similar scenario as the one I described, the court might reach a different decision because the facts might be different, because there will be a different law applicable. So this is just to give you an overview that it's possible, but it will very much depend on the circumstances of your case. And also, the second point is that the position of the court might shift in time. So I've mentioned quite a few times that the UK courts have been very open, but that not guarantee that will be the same in the future. For example, if you have a jurisdiction where the courts are encouraging this type of serving the application via NFT, recognize it crypto as property, but then you have, in a couple of years, you have a decision from the government saying trading crypto is illegal, then if you go to the court and try to enforce any sort of rights of your crypto, the court will say, sorry, we cannot do anything because now it became illegal, even before everything was accepted. So this might change in time. And the last point I want to highlight is, don't wait until you go to the court. That might be a very painful and long time process. So try to take precautionary measures. Read those boring terms and conditions. If you're trading a lot of money, take insurance against cyber attacks. Speak with a lawyer, of course, but first of all, be cautious before doing something, especially if it involves a lot of money. I will just say thank you to everyone. Here's a link to our LinkedIn page where you can find what type of content we publish, what we discuss about in our Slack, and you'll find information about how to join the forum and continue the conversation there. If you have any questions, I welcome them.
Thank you very much for the presentation. My question is that, like you mentioned, that the ownership between the platform and the crypto owner or lender, user, basically. Have you seen any difference in interpretation or any comment or any decision in regards to non-custodial wallets and the custodial wallets?
No, I haven't seen. I think at the moment the decisions that appear before courts are very few, and you have some general, you have just the taste of what's happening out there. They're not that granular and that specific. So it's just, the courts are just getting accustomed to deal with these issues.
Okay.
Please. The future of arbitration. The question is about arbitration because our forum is mostly forum of dispute resolution lawyers focusing on arbitration, which is a specific type of solving disputes outside court. The future between arbitration and tech, I think arbitration will provide specialized knowledge for solving this type of disputes, because whenever you go to court, the judge that you have is a judge who has general knowledge about everything. Whereas when it comes to arbitration, you can choose the person who decides your dispute based on their background, and you can have a look at the beginning and see, does this person know about crypto? Does the person know what a distributed ledger is? Does this person know what's an NFT? And that increases you the chances to have your decision decided by someone who has the technical knowledge. Please.
Yeah, thank you for the presentation. One question more on like the precedents that like these like cases might set. Is it like likely that like the cases that are like being like judged now like will like take precedence like in the future, or like is it we just don't know and there's a lot of uncertainty?
It very much depends on the jurisdiction. In the cases that I cited, are mostly from the UK courts. UK courts follow what is called a common law practice, meaning that precedents are binding. So whatever was decided before should be followed, of course, under different conditions. So when we talk about common law jurisdiction, as UK is, then it's very likely that the court will follow what was previously said. And even in other jurisdictions, like France is called a civil law jurisdiction, where the precedent does not have value. Even if the precedent is not binding, as it means that the court is not obligated to follow it, it will have a good persuasive value, as in the court will be inclined to follow the same pattern, just because in general they have the obligation to ensure a continuity and uniformity of result. But it's not mandatory. They will do it just because it's important to show that justice is the same for everyone. Any other questions? If not, you'll find us on LinkedIn, and you can see the type of content we have there. Thank you so much.